Good afternoon. This is line 9 on the docket, and this is the matter of Angelina Lodice. This is Judge Jessica Torres. With all parties present, please identify themselves for the record. We'll start with the attorney for the minor child. All right, moving on. We'll move to the, petitioner. Is the petitioner present? No response. All right. Mr. Lodice, if you could put your first and last name on the record.
Hi, my name is Matthew Lodice.
Let me just double check. Is the attorney for the minor child present?
Your Honor, I am here. I'm at the courthouse. I just got kicked off, so I'm back on.
Just give your name for the record, sir.
Oh, I'm sorry, Your Honor. Mike Culkin for Levine Litigation.
And I see a person on the line by the name of Jeremy R. If they could give their first and last name for the record. Again, no response. All right. Right. I really can't go forward with the proceeding if I don't know who all the parties are in the case, and because this matters are confidential. So, Jeremy R., if you are not a part of this case, please remove yourself from the meeting.
Could it be someone left their computer open from a prior case?
No, they're all individualized. All right. All right. Well, I don't have the petitioner present. So, I mean, we were asked to have this proceeding. Madam Clerk, are you able to remove parties from the proceeding?
Yes, I can remove them.
Okay, I'll ask one more time. If the person who has identified themselves as Jeremy R. will take themselves off mute and identify themselves for the record. Again, no response. Madam Clerk, can you remove that person from the proceeding?
Yes, Your Honor.
So we're here today on the first presentment and I'll note for the record that person was removed from the proceeding. And now I have another person added on to the proceeding. Will the person who's just been added on to the proceeding identify themselves for the record? So I do see an indication of someone identifying themselves as Theodore Antar on the proceeding, but they are not identifying themselves for the record. Again, I'm going to request that the person who is identified as Theodore Antar identify themselves for the record.
Hi, I'm sorry. The link was not working. I just was able to connect.
Put your first and last name on the record.
Theodore.
Repeat that again. The interference prevented us from hearing your name.
Theodora Antar.
So here on the initial presentment of a probate transfer matter. I will disclose for the record pursuant to Rule 211, subsection E, that I have been notified that I am a identified defendant in a federal action that was filed by Ms. Antar. With respect to this matter, I will also advise pursuant to the practice book, filing of a complaint or a lawsuit is not qualification for automatic disqualification from the file. So we are here for the first presentment. Mr. Lodice, did you plan on hiring an attorney or did you plan on requesting one from the court?
No, I feel I plan on representing Pro Se, Your Honor.
So consistent with Connecticut General Statutes 45A 717, I am to advise you the nature and meaning of the petition for the termination of your parental rights. Termination of parental rights has been filed by the petitioner, in this case, Antar, Theodora Antar, and there's an indication that she's alleged multiple counts on the termination of parental rights. If she is successful either on the adjudication and the disposition, that would permanently sever your parental rights to your minor child. Do you understand that?
I understand, Your Honor.
Do you still wish to proceed as a self-represented party?
I do, Your Honor.
So the respondent parent has so been advised, indicating that he wishes to proceed on his own. So with respect to the matter itself, I believe a study pursuant to the statute is required, and they have 90 days to produce that study. So we can continue the matter past that date. Madam Clerk, do you have a date?
One moment, Your Honor.
Your Honor, while you're getting a date, it's come to my attention that my firm has been named, and I think my associate's been named. So I would ask the court whether or not that is a conflict. Basically, I think that, I'm going to have to notify a malpractice carrier, probably pay deductibles, to respond to a complaint. And I don't know if that rises to the level of a conflict. I would ask to have another counsel appointed. Where the case is just starting, Judge.
At this point in time, are you orally moving to be withdrawn from the case?
Yes, Your Honor, I am.
All right. Does any party wish to be heard on that?
I would, Your Honor, please.
You go first.
Yes, I would say I'm okay with that. If I would also just like to ask if the court can appoint a GAL due to the child's age. She's only 4 years old, and usually AMC are for children who are older and can express their own wishes and articulate. My daughter is 4 years old and she has disability of adjustment disorder, and so I'm asking if the court can, in the interest of justice, appoint a GAL in addition to an AMC, or one that can act as both.
Mr. Lodice?
What I wanted to say is pretty much anyone that does get named as Angelina's lawyer or representative will be pulled into the lawsuit. Miss Antar has pulled in every judge, lawyer, person, friend, family member, anyone and any person, what should we call it? Any organization, anything that has anything to do with our daughter, and even extensions of that have been pulled into litigation with her. So I feel like anyone that you do have represent her is going to just be added to the lawsuit as soon as that party's named.
Objection, speculation.
I'll ask it this way, Ms. Antar. Do you have a federal lawsuit pending against Attorney Culkin's firm?
Against attorney who?
Levine
It's
litigation.
Levine litigation.
Yes, and I do want to put it on the record that I will be filing a motion asking for you to recuse yourself from this case due to several conflicts of interest. And I'm putting on the record that despite the fact that it is not required, that I do think that it would be in the interest of justice to do that. I had not spoken to anyone other than Joshua Pascal from the firm and another individual. Joshua stated that he was planning to today ask that an attorney be appointed for me, as well as an attorney, GAL, and a CASA specialist for Angelina for the interest of justice. I was also told by the clerk when this case was transferred that by statute, I also had the right to ask for appointment of counsel. And you actually told me that I don't have that right. And I want to know why I'm being denied that right.
I'll turn it back on you, Ms. Antar. Can you identify the statutory number that requires the court to appoint you an attorney?
I actually did in my prior motion, and I don't. If you give me an opportunity to have a little bit of time to get that, I would be able to look at it. But per statute, it says that any parents, the child and parent or parents, I believe it says, have the right to counsel, and if counsel is if they can't afford counsel, they have the right to ask for that. And when I first spoke to the clerk, she instructed and said, "You have the right. You should probably do this as soon as possible." Joshua said the same thing. Everybody said, "I have the right to ask for an attorney." Why am I being denied that right?
Ask for the attorney.
I'm sorry?
I believe the statute refers to the court may appoint in the interest of justice. So it's not shall.
What statute it says? Can you please tell me which statute you're referring to?
No. So I'm going to leave it in your hands. You determine if you wish to make an argument and say that the statute says shall, then please submit to the court the statutory reference for which you claim the court is required to appoint you counsel.
So I just want to confirm, is the court denying me the right to have an attorney? Yes or no?
I'm not answering your question.
Okay.
But I noted that you're making the request consistent with Practice Book 122 subsection B to have me disqualified from this proceeding because of the indication that you've perceived me to be or biased in this case. So what I will do, consistent with your request, is I will schedule this for a hearing, and I will refer it to another judge to address the issue of disqualification, of my disqualification. And we can schedule that for, let's see, we can do that November 8th.
So hold on one second. Will this be in person or?
It's in person.
Just take a look.
What type of hearing, Your Honor?
I'm sorry, I have a conflict on that date. Is there another day that we could do it?
It's on November 9th.
And what time would we do?
Probably do 10 to 1.
And so just so I understand, because when I spoke to Attorney Pascal, he said to me that we would have a hearing that would be scheduled for this case as a evidentiary hearing, and stated that at that point I would be able to have witnesses and I'd be able to show evidence. And
well, the first thing that has to happen is the court is required to request from the Department of Children and Families a report. And I'm so ordering that today. And it takes 90 days for it to come back. So after that report comes back and the parties have had a chance to review it, then they can determine whether or not a hearing is necessary.
Okay, and so I'm clear, because I haven't been contacted by anybody from the Department of Children and Families. And so is there somebody that's supposed to be contacting me? I don't know what's going on here. I'm just completely in the dark.
I just ordered it today. So
Okay.
The department will receive of it today and they will reach out to you. probably with the information that you've presented to the court regarding your contact information.
Okay, and then just so I'm clear, am I able to get, I know you were saying that you were going to refer for a hearing on the issue of whether you should recuse. Is there also a possibility to have a hearing regarding the option of me having an attorney? Because I was told if it's denied, I have the option to have a hearing on that. Is that true?
Correct. So what I will do today is I will appoint on a limited basis an attorney in the interest of justice to address the issue of disqualification. And at that hearing, if it's still needed, that judge can decide whether or not it is in the interest of justice to have an attorney appointed for you for the case itself.
Okay, and if they say they don't want to or they don't think they should, I still would have an option to retain my own private counsel, correct?
Always free to retain your own private counsel. Just be please understand that you will have to be placed under oath with respect to the information you've presented and swear that the information you've provided is true and accurate. But do you understand what it means to be represented by counsel, Ms. Antar?
Can you please confirm, or
That means an attorney will be representing you. And so when you get court-appointed counsel, or in this case, interest of justice appointment, the attorney will file their appearance. And that attorney will have the obligation to file any legal proceedings. It is not in addition to appointment. That means you will have to connect with your attorney, and they will take the lead on the proceedings that will be upcoming.
So does that mean I have no control over anything? Because don't I have the opportunity at any time to terminate that attorney-client relationship if I feel that they're not protecting my interests?
There's the issue. If you think, based on your training and experience, that you can handle a case better than any court-appointed counsel, then perhaps you do not want to have the court appoint counsel for you. The decision is yours. But initially, I will grant your request for an appointment of counsel on a limited basis to adjudicate or resolve the matter of my disqualification.
Okay, and are you able to grant the request of either having a separate GAL or one who can act as both, and or a CASA specialist for Angelina? She's never had a GAL ever.
In juvenile court, when children are under the age of 7, the attorney for the minor children will often serve as both GAL and attorney for the minor child. In the event that the attorney for the minor child feels that there is a conflict, at that point in time, the attorney for the minor child will indicate to the court the need for a guardian ad litem.
Okay, the reason I'm asking is because per my conversation with the appointed counsel, Attorney Pascal, he stated that his intent was to ask today that the court appoint a CASA specialist and in that protection of justice. When I had tried speaking to him prior, he said he's only the AMC. He's not a GAL. So I just want to make it clear, will this new appointed counsel act as both, or is that something I can ask now and that you can consider?
I will leave that to the new attorney for the minor child. As you've just heard, Attorney Culkin's firm, Levine Litigation, has been removed from this case, and therefore I will leave it to the new attorney for the minor child to make that decision and bring that to the court's attention.
And as far as the CASA specialist?
They serve as guardian ad litems, and I'm going to let the new attorney for the minor child advise the court if they feel a guardian ad litem is needed.
Okay, and so will I be contacted via mail or other means to when that person is or firm is appointed?
I understand that when the Office of the Chief Public Defender appoints counsel, then the counsel will file an appearance and then obtain your contact information.
Okay, and then just so I understand too, there's no option for e-filing for non-attorney, and if I wanted to see any updates, there's no way to see it online at all. You would have to either call the clerk's office or go down and be able to see like any updates like that, or does the court send a letter every time something gets done?
You'll have to, with respect to e-filing, these are removal from probate, so I'm not sure of the exact requirements. You'll have to check that up with the judicial department and the court operations.
But any decisions or orders or appointments or things that the court does, they do mail it to us all, correct?
I believe that is how you would receive notice.
Thank you, Judge. Your Honor, I don't mean to interrupt. I was waiting for an opportunity. If I'm officially not on this case anymore, I think I should disconnect at this time.
Yes, you are excused from the proceeding.
Thank you very much.
So let's see, 90 days. Madam Clerk, do you have an in-court review date for 90 days out?
One moment, Your Honor. About Thursday, January 25th at 3 o'clock? Or would you like it earlier in the day?
Is this going to be in person?
No, this will be virtual.
Okay.
For now, it'll be virtual.
And so I'm sorry, this is going to be for is this going to be the hearing that is not an evidentiary hearing, or I'm sorry, could you just explain again what this hearing is?
It's an in-court review to acknowledge the receipt of the home study and to report back to the court on the position of the parties.
And so after
that,
they'll make a decision
if another.
Okay, and then at that point, they'll decide whether to do or not another trial or another hearing.
Correct. The parties can determine whether or not they wish to accept the recommendations issued by the Department of Children and Families or contest it and have a hearing.
Okay, and so you said you were doing the 25th of January at what time?
3 o'clock in the afternoon.
Okay.
So let's see, I see November 9th. So you'll be back here on November 9th, 2023.
And so if that one,
I'm
sorry, is that one is just going to be for the recusal, is that possible to do on Teams as well, or is that going to be in person?
That would be in person.
Okay, so November 9th, and I'm sorry, can you say the time one more time?
10 o'clock we begin.
November 9th at 10 o'clock. And as far as you said you were going to appoint somebody, I will get notified. They'll reach out to me once that's done.
Correct. Or you can contact the Office of the Chief Public Defender to determine your who was appointed.
Okay.
Your Honor, what time was that? I couldn't hear.
10-1.
I know. 1 o'clock? Sorry.
Starts at 10 o'clock in the morning and goes until 1 o'clock in the evening.
Thank you, Your Honor. I'm sorry.
All right. And then the court will issue a ruling after that. I don't know when.
Okay.
All right. Anything further we can address today?
No.
Thank you, everyone.
Okay.
Thank you, Your Honor.
Thank you.